Hi, my name's Joanne Caffrey, and I'm going to do a short presentation in relation to calming rooms and when good intentions become abusive practice. Now, the main focus of this presentation is in relation to the education sector, but the same principles and practices apply to any service provider. So what I want to go through first of all is the issue about the calming rooms, and it's not just about the name. And we're seeing all sorts of rooms out there appearing, either called blue room, yellow room, calm room, timeout room, safe room. The name might be nice, but it's about the room itself, as in the physical build of the room, the use of the room, and the policies, procedures, and quality assurance around the room. All those three areas are important to take into consideration. Also, what we're going to look at as well is about the standard health and safety risk assessments being insufficient for a room where a child in crisis may be placed. So typically we see the risk assessment paperwork for such rooms, and it's been completed by a member of staff who has completed some basic health and safety risk assessment training, but it's not at all applicable to the risks that could happen in such a room. For example, if we're considering self-harm and ligature points, it only takes 2 millimeters for it to become a ligature point, and it's not unknown for a child to either attempt or actually commit suicide whilst in a so-called safe room. For example, in 2004 in America, a child called Jonathan King, he hung himself whilst in a school safe room or calming room. So it's not just about the name of the room, it's about the room itself, how the room is actually used, and then all the policies, procedures, and quality assurance around it. A brief look here at the legislation. At the end of the day, we have to comply with Acts of Parliament, regardless of any national standards out there directing you how to use these rooms. We've still got legal Acts of Parliament to follow, such as the Children's Act. Overuse of any kind of restraint or use of force can actually be abuse on the child themselves. Also, Offences Against the Persons Act, such as assaults, and Health and Safety at Work Act at the end of the day as well, because this is applicable to your staff to keep them safe, but also the service users. And then we've got the human rights. Moving on to one particular aspect of law is the offence of false imprisonment, and fully understanding how this then can comply or apply to these kind of rooms. And the offence of false imprisonment, although it's at common law, it carries a penalty of up to life imprisonment. And false imprisonment is about the unlawful and total restraint of personal liberty of another, whether by constraining them or compelling them to go to a particular place, or by confining them to a prison or police station, or in a private place, detaining them against their will in a public place. The wrongful act of false imprisonment is the act of placing an unlawful restriction on a person's freedom in the absence of any legal right to do so. So the issue here is this word unlawful. Just because, for example, schools have a power in order to use restraints on children doesn't mean to say that it's lawful when they're using it. And the term lawful, every time that you either contain a child or restrain the child, you need to be able to demonstrate that it was necessary, reasonable, and proportionate in the circumstances. If we look at some current cases or recent cases in the UK where so-called calming rooms have proved liable, this particular school, they were using their calming room, which they called a blue room, and a 15-year-old boy was locked in there up to 6 times a day to control his behaviour without a court order for depriving him of his liberty. The actual school were found liable in relation to this, and compensation was awarded. And if we jump forward then to August of 2017, we've got an example here of where the head teacher was found guilty of professional misconduct for the manner in which a school used a so-called calming room. And some of the key issues here from this room, and again, there was no evidence of any malice involved in this, but the children in question were being locked in, they were being left unattended, there were no suitable safeguards, and it was inadequate policies and paperwork for the room and the restraints, and a lack of knowledge among staff. So the circumstances of this was they had a room which they took children to if they deemed that that child's behaviour was getting challenging or the child was actually being physical. The child was then left in that room. They then made a room within that room, which was a smaller room, and this room, I believe, was 2 metres by 1.5 metres. So children then were being put in this room and held in against their will. But initially the children were able to get out of the room because there was a handle on the inside of the door. So this handle was then raised higher. Ultimately, that heightened handle was then removed completely from the inside, so there was no way that the children could actually get out, and it relied on an adult being outside the door, allowing them to get out. On one occasion, a member of staff got locked in that room, and so a control measure was put in place by fixing a bell, but it was too high for the children to ever reach it. Also then, the children were left unattended whilst in this room, and varying reports from the members of staff, anything between 5 minutes and 20 minutes, the children were left unattended. But the policy that the practice that the staff were adopting was that they would keep going back every so often to check on them. But that was deemed not to be a suitable safeguard, that the children were left unattended in this room, and plus there was no CCTV, there were no windows for them to be watched. The paperwork itself was all inadequate, so although paperwork did exist, it was deemed inadequate, and the lack of knowledge among staff about how to actually handle challenging behaviour. Also, a point here about the general health and safety risk assessments. They tend to be inadequate, and also the aspects of these rooms gives different challenges in relation to your policies and procedures. So it's not only ligature points which we need to remove from these rooms, but staff also need to understand about what medical emergencies may happen in these rooms, how to safeguard and how to deal with them. So how can we help you? Well, we have a multidisciplinary team. We combine the legal, the therapeutic and the medical models to hopefully be able to help all workplaces, whether that be education, care, clinical or custody. We can then look at your assessments, or actually do your assessments, and look at it from the point of view of the staff, the service users and the actual rooms. We can look at your policies and procedures and make sure that they are actually looking at being used in the correct way. When we're looking then at training of staff, we deal with everything from conflict management to restraint, all about the positive and proactive management down of challenging behaviour, and all the therapeutic as well, because a lot of children who are actually being put into these rooms or using these rooms are actually on the spectrum or have got sensory integration issues. And our team occupational therapist is able to do sensory integration assessments and help staff and train staff in relation to recognition and managing of sensory integration issues. We can also give ongoing advice and consultancy, and also provide expert witness services in relation to the use or abuse of these rooms. Some key questions for you to ask yourself is, if this room is a calming room, ideally the child takes themselves to this room. They are not being dragged kicking and screaming against their will. Also, if this is a calming room, the child can choose when they leave, and that they're not locked in there. And also that this is for use in exceptional circumstances, not a regular daily or even weekly use. And if you are using a room such as this for the same child regularly, then I would suggest there that you need some long-term managing down and identification in relation to this child or service user, because it's getting to the bottom of why this child or adult is actually needing to be using this room. And ultimately, I own the company Total Train. We are a multidisciplinary company. We can assist you in order to safeguard your vulnerable people, whether that be in education, care, clinical or custody. Please never hesitate to make contact with us. Thank you very much.